So ultimately, this is a very serious issue affecting my liberty also, my lord. In the instant case, there is prima facie evidence before this court of abuse or misuse of state and police machinery in registering cases for investigation based on half-truths, fiction, concoctions, and non-event. In fact, some of the complaints based on which FIRs have been registered have been described as fill-in-the-blank FIR. The gentleman who wrote it, he has autographed each FIR. One man has written all 34 FIRs. It's indeed shocking. Also, my lord, learned advocate general said that 2-3 complaints he has written for the BJP. Let those records also come.
No. When the FIR for the BJP, the same tick mark.
Yes.
Tick mark.
The same man with the same tick mark.
But who has done it? That's the point. Therefore, there needs to be an SIT. This is a further reason for an independent SIT. That what kind of FIR is this and who is doing it? Now kindly see from serial number 10 onwards. I can read all, but just to give a serial number 8 also, if your lordship will see. It's more or just see serial number 8. It's open-ended. Again, at 9 a.m., the FIR other accused person surrounded the house of the complainant, destroyed the house, assaulted the wife, outraged her modesty. Complainant and wife came out of the so-and-so. They destroyed the motorbike. He tried to rescue his wife, assaulted. Then local people rushed to the spot. Accused threatened the complainant. Now, all open-ended, my lord. Anybody can be rounded up and picked up like this. Now come to serial number 10. It's very interesting. Serial number 10. Now, this FIR again is a written complaint, and complainant is what Anita Mondal. On 23rd May at 11:40-12 at night, shop of the complainant in Bhaturia, FIR named accused persons are miscreants and goons. Under the influence of Suvendu Adhikari and Meghna Pal, miscreants went to the complainant's shop, broke open the door with iron rod and hammer, etc., threw cylinder in the pond, took all articles, could hear the miscreants destroy her shop. As she was scared for her life, she was standing far away. They were abusing the complainant using slangs, etc. The complainant suffered a loss of 2,50,000. Now kindly see serial number 12. 12, 13, 14. 12. Now, this is a written complaint. Complainant is somebody else. But all these are being scribed by the same person. On 23rd May at 7 in the morning, in various booths, FIR name accused persons are influential and powerful goons. Under the influence of Meghna Pal and Suvendu Adhikari, FIR so-and-so under his leadership and other persons carrying sharp weapons went to the house of the people in Trinamool Congress located within the areas of the booth on bikes and attached their houses and abused them. Accused persons looted and destroyed their houses, beat up 6 children, etc. Then, my lord, serial number 13. At 7:30 in the morning on the complainant's own house, FIR named accused persons influential, powerful goons on the date and time suddenly came to the complainant's house, attacked her by physically abusing her, tried to kill her by strangling her. Person started destroying. So this attacked her, tried to kill her by, this is common. This if your lordship reads the vernacular, the expression is common in all these 30 and odd FIRs. Yes, at 141 again, this written complaint serial number 13 is drafted by the same individual, whose names I have just read. Under these circumstances, just the last line, under these circumstances, the complainant and her family and supporters of TMC are not feeling safe. Then next, serial number 14. Accused persons came on the complainant's house on bikes, attacked her, they verbally abused her. Accused tried to molest by opening their clothes, etc. The accused persons are doing this under the influence of Suvendu Adhikari. So ultimately, this is a very serious issue affecting my liberty also, my lord. And my lord, I can cite a series of orders in my own petition. This happened also in 2021 when I defeated the present incumbent chief minister in Nandigram election. At that point of time also, series of FIRs like this were registered against. I had come to challenge those. There are a large number of orders. I just want to show one of those orders to your lordships. Just pass on. Can you pass on the compilation? Just one of those orders. We have a whole compilation of those orders. But just kindly have one order at page 30. This is an order. This is an interim order dated 6 September 2021, which they have taken to the Supreme Court on 3 or 4 different occasions. But the order has sustained and not been disturbed. This was in relation to 6, kindly at page 30.
Yes.
I'm just going to read this. The writ petitioner complains of abuse of state and police machinery. The writ petitioner here is petitioner number 1 also. By ruling dispensation in registering 6 FIRs against him in 4 different police stations, claiming violation of rights under Article 21. Writ petitioner seeks intervention of the court under Article 226 of the criminal proceedings being filed against him. Alternatively, the petitioner seeks transfer of investigation in the said 6 FIRs. Writ petitioner is a member of the Legislative Assembly, leader of opposition. Until December 2020, petitioner was member of the political party which was in power. Since 19 December, he joined rival political party, contested elections. While petitioner was member of the current ruling dispensation, he was a transport minister in the state cabinet and was also in charge of Department of Irrigation and Waterworks. Prior thereto, he was a member of parliament. According to the council, victimization and harassment by the state had begun immediately after the petitioner changed political allegiance in December 20 and intensified after assembly elections in May 21. The state fired the first salvo by removing a security cover, etc. My lord, I can leave these few pages, my lord. Your lordship may then straight away come to where the findings are. Just kindly also glance over page 37, my lord, where the learned advocate general had raised a demur and relied on Pepsi, etc., that this court should not entertain the petition. All that was considered by the court. And then Arunabh's judgment and all judgments were relied upon. And at page 41, the court then concluded, in the middle of the page, 41, in view of the above, the court is of the view that writ petition and prayers made are eminently maintainable. Then, my lord, on merits, I will leave that. I will take your lordship straight to the findings. Just kindly have page 45. Page 45.
Yes.
The observations, the above observations are prima facie. Now, this is first. The writ petition is entertained by this court in view of the prima facie satisfaction that the police of the state in series of 5 FIRs registered against the petitioner appear to have acted overzealously and maliciously for the following reasons. Now, reason A, your lordship may leave it as security. B, well over 7 and 8, and in some case, 13 consecutive FIRs have been registered against the associates since the recent assembly election. The associates of the petitioner have also changed partnership with the political party. An incident of 18 is registered as an FIR without even a preliminary inquiry as regards delay in lodging the FIR. Then, my lord, those are all on merits. But please have page 47. Very important. Page 47. The court finds substantial force in the petitioner's argument. Prima facie, there appears to be an attempt at implicating and victimizing him in criminal cases, malafides, malice, and collateral purpose in registering FIRs against the petitioner and his associates, a scheme and or a conspiracy or pattern or stratagem appear to have been devised to entrap the petitioner and his associates to ensure their incarceration and custody, to embarrass them. This is the point I'm trying to make here. It is argued that most of the aforesaid FIRs are in respect of small flimsy act alleged against the petitioner. There are threats and public speeches stated to have been made by the petitioner. Some of the speeches are stated to have hurt the sentiments of a section of citizens. There are threats and intimidation alleged to have been made while canvassing for votes. In fact, some of the complaints based on which FIRs have been registered have been described as fill in the blank FIR. The name of the complainant, age and father's name have been left blank to be filled in at random. I pause here. Now they are not doing fill in the blanks. Now they are naming people, but somehow, sometimes, my lord, something gives away the game. The gentleman who wrote it, he has autographed each FIR. He need not have done so. We would never have known. But one man has written all 34 FIRs. It's indeed shocking with respect, my lord. The name of the complaints, age and father's name have been blank. Such blank complaints appear to have been handed out casually to persons owing allegiance to the ruling dispensation. Some persons appear to have left complaints at police stations after filling in the blank in which the concerned police station have mechanically, overzealously, and in furtherance of the dictates registered FIR. The actual intended consequence of FIR is that 26 days in a month, writ petitioner would be confined in police stations to respond to notices under 41A. It is maybe necessary to refer to submissions of learned senior counsel that his client had contested the last assembly election against the present head of the dispensation and won. Personal vendetta of some person owing allegiance to the said person, therefore cannot be ruled out. The reasons behind dragging one single individual and family members in such volume of complaints are argued to be irrational and unexplained. Now, this is the court now speaking. This court refers to hundreds of writ petitions that have been dealt with in the last few months in respect of FIRs against various persons of offences similar to those referred to the FIRs. In most of these cases, either proceedings under 107 or 116 were drawn up, and the police conducted inquiries and warned such persons. Then, my lord, the learned advocate general submissions are noticed. If your lordship will have the last para. However, that by itself cannot give a carte blanche to the state to indiscriminately register FIRs against the petitioner, mechanically or motivatedly so. This court refers to the observations made in paragraphs of the order dated 6 September set out in detail. Then the allegations for counsel of the petitioner in each of the FIRs were an attempt to frustrate the protection granted cannot be brushed aside. Then Niharika is noted. Then it is noted that indeed a writ court must be circumspect and slow to quash FIRs. However, in the peculiar facts and circumstances of the instant case, the fact that the writ petitioner is an elected representative of the people holding the post of leader of opposition, the court's mind is not free from doubt that the state police machinery, either on its own or under the influence of persons in the ruling dispensation, is out to completely stall the public life and personal liberty of the petitioner. There appears to be a calculated design to deprive the liberty of the petitioner. As stated herein above, there appears to be an attempt to bypass the interim protection granted, which has been upheld by the Honorable Supreme Court. Then, my lord, court says, in these circumstances, this court is of the view that each and every FIR referred to in the petition shall remain stayed. The police shall not register any more FIRs against the petitioners without the leave of this court. The prayer for transfer of investigation shall be considered after affidavits are filed, etc., etc. This writ petition, my lord, has been argued at great length. We have concluded for the petitioner. State has concluded. There were two complainants counsel. They have one has concluded. One will probably conclude on Thursday, and then rejoinder, and then that is the status of these two petitions in which these orders were passed. This order was challenged in 4 different rounds in the Supreme Court. First round is page 6. First, the state went, withdrew. Then they made some complainant to go. That got rejected. Then second complainant got rejected. Then the state again went. Every time this order has been upheld by the Honorable Supreme Court. So, my lord, that in these circumstances, my lord, shall I give the page numbers where the orders have?
Yes, yes.
Yes. So, page 61A, first is the first round when the state went, immediately after the order was passed. On mentioning the order is taken on board. On 8 December, the following directions was issued by the single judge. Dr. Singhvi, learned senior counsel appearing on behalf of the state, submits, as a result of the blanket stay which has been issued on registration of any FIR against the respondent, the petitioner state is unable to register an FIR in respect of an incident which took place yesterday, when certain deaths are alleged to have taken place in the course of distribution of blankets. Since the single judge is not available for judicial work, it has been submitted that specially petition had to be instituted before this court. Even if the single judge who passed the order is unavailable for work at Calcutta by virtue of his judicial assignment at Port Blair, petitioner has the remedy of moving the learned Chief Justice for appropriate directions. In view of the above, Dr. Singhvi, learned counsel, states he seeks to withdraw the SLP to enable the petitioner to move the Chief Justice without prejudice to his contention. It is clarified we have recorded the submissions and not expressed an opinion. Application was moved, not granted. Then the second round is at page 125. The second attempt to get this vacated, stayed, set aside, is at page 125.
Yes.
This time, my lord, it is my respectful submission that one complainant in one of the FIRs were persuaded by the state to go and challenge this order, my lord. Now, in that also, the state SLP was dismissed. Permission to file the SLP is granted. High Court of Calcutta is in session of the proceedings. Next date of listing is 10th January. In terms of order so and so, petitioner would be at liberty to move the High Court for being heard in the pending proceedings. We permit the petitioner to do so. In this view, it is not appropriate to exercise jurisdiction under 136 at this stage. Petition is accordingly dismissed. Then, my lord, third attempt is at page 110 against this order. This is also disposed of by noticing, my lord, at page 112 in para 6 and 7. That court has been appraised that state of West Bengal has moved certain applications for vacation of the stay, which was granted on 8 December, to take applications for modifications and dispose of the same. No modification is there, my lord. The stay continues. Then they persuaded another complainant in one other case to approach the Supreme Court. That is at page 114. Again, the Honorable Supreme Court heard counsel for the petitioner as also for so-and-so. Though in the instant petition, the petitioner has sought for detagging of the writ petition. At this juncture, we see no reason to exercise our discretion under 32, since relief should be fought before the High Court. Be that as it may, we note that the High Court had listed both petitions along with applications for consideration on 26 June as 2 p.m. as an assigned matter. We hope petitions would be taken up for consideration and party would cooperate, etc. So that is where it stands, my lord.
Well, at least two complaints are here, where the same person had scribed on behalf of the complainants who were from the Bharatiya Janata Party. Now, Millard, I'll just give you a lot of example, Millard, so to satisfy the conscience of the court. Millard, the name of the petitioner number 2 over here is Sumon Chakraborty.
Yes.
Just to satisfy the conscience of the court.
Can we also
give him one? I'll read and hand up. Kindly see, Millard, on the left-hand side column, Millard, serial number, petitioner number 2, name is Sumon Chakraborty. Millard, against him, Millard, 1, 2, 3, 4, 5. FIRs, he is named. Now, in each of the FIRs, where on the right-hand side column, immediate thereafter, your Lordship finds in respect of Nondigam PS case number 442, Millard, there are 32 accused, of which only one has been arrested.
400?
Millard, in the third column,
400.
the first case, Nondigam PS case number 442.
442.
Kindly see the immediate right-hand side column.
Yes.
There are 32 FIR name accused
person.
in Millard, Nondigam PS case number 442,
Yes.
of which, Millard, only one have been arrested. Please take the next one. That is Nondigam PS case number 456, of which, where Millard, there are 17 accused persons, of which, Millard, only 2 have been arrested.
This is what the petitioners say.
Yes.
That you are selecting out persons to arrest them.
No, but these are all, Millard, according to them, TMC workers.
No. BJP workers.
Oh, BJP, very well. BJP workers. Very well.
BJP workers.
If all are BJP workers, then out of 32, if only one is arrested, Millard, in course of investigation, Millard, I have a right to arrest. Well, these are all cognizable offences, no dispute on that, right or wrong. I have a right to arrest, but Millard, can this depict a picture that, Millard, the police is indiscriminately arresting the BJP workers? As against 32, one has been arrested. Next case, as against 17, only 2 has been arrested. Third case, 26 people, no one arrested. Fourth case, 22 persons, 1 have been arrested. The fifth one, 15 persons,
None arrested.
none arrested. Therefore, 2 and 1, 3, total 4 has been arrested.
How many ruling party members have you arrested?
So I'll take instruction. I'll take instruction. But Millard, the point is, Millard, please consider one thing, Millard. But I have no fascination in Milord in registering cases. Huh? Acha. The same person, Milord, had scribed 2 FIRs. As against those, 3 have been arrested. Out of how many accused?
They must have themselves written them out.
So he's a common scribe. For anybody who's there, he goes, he's there to.
Who are the complainants? They may have themselves got it done just to.
No.
After this petition copy is served. And what are the dates?
To these surmises, but a writ court cannot go into these surmises. My learned friends may have a very good case on law, but let us not go into that. But if his case, the first case is, which creates a suspicion, is that the same person has scribed all the complaints, Milord, he should also be in a position to answer how could the same person write complaints for
On
the
their
person
behalf.
on their behalf. If it is suspicious for me, it is suspicious for them also. But I don't think that there can be any suspicion on this, Milord. It is our common knowledge, Milord. Even, Milord, in our younger days, we found that, Milord, when letters used to come to our house for the maid servants and all, Milord, they used to bring it to us only to read it. Or to send letters, they used to get through us, Milord, they used to write. Well, this is not uncommon. What I was very respectfully submitting is, Milord, this cannot be a ground to, Milord, question the veracity of the FIRs and registration of a case. Number 1. Number 2 is, Milord, what is my duty? Milord, as a police or as the investigating agency, Milord, under section 154, Milord, my duty is, if a complaint comes to me either orally or in writing, Milord, I have to reduce it in writing, and then, Milord, I have to register a case. But I do not have any, Milord, obligation, statutory obligation or anything of that sort, as to find out whether, Milord, whatever points my learned friends are raising, to look into that. I do not have any obligation to go into the veracity of the allegations. I have only one obligation, to register a case for investigation. Then, Milord, it follows. Wherever, Milord, there is a indolent investigation, Milord, your lordships have, Milord, sped up those investigations. Wherever your lordship has found faulty investigation, Milord, there are, Milord, ways and means to arrest that. Wherever your lordship has found overaction on the part of the police, Milord, your lordship has also taken note of that and, Milord, passed appropriate directions. But, Milord, the fact that one person has written complaint possibly, Milord, cannot be a ground. The other aspect of the matter is, Milord, that all along, Milord, it has been held that an FIR is not an encyclopedia of facts. It is only, Milord, information for the commission of an offence. If it is a cognizable offence, I have a right immediately to spring into action. If it is not, if it does not disclose, or if it discloses non-cognizable offences, then we'll have to go before the magistrate and whatever follows thereafter. Therefore, Milord, these facts, but on the face of it, maybe, Milord, very shining, Milord, or Milord, what should I say, Milord, presumptions. But, Milord, at the end of the day, Milord, on the legal aspects, Milord, I don't think, Milord, this has got anything to do. Now, Milord, the next point is, Milord, I will not, Milord, answer, Milord, what my learned friends have cited, Milord, from, Milord, these unreported decisions, or even if it is reported, I have not been handed over these copies. The only thing I could gather is that, Milord, whatever has been cited before the court are all interim orders. And interim orders, Milord, I need not, Milord, dilate on that, Milord, cannot be cited as precedents. Therefore, Milord, today, Milord, there is nothing which has been brought before your lordship except apprehension that these FIRs should be stayed or they should go before some other agency. In fact, Milord, some other agency is not a party. I will not say on that. But as of today, Milord, in my very respectful submission, it does not call for any, Milord, what should I stay or, Milord, fettering, Milord, the hands of the investigating agency. But I can come up with, Milord, a report with your lordship or an affidavit, whatever your lordship feels would be proper, to, Milord, disclose what has happened. But as on today, Milord, none of the rights of any of the parties have been infringed. Because, again, Milord, I go back to the first principles. One has to come and disclose, at least demonstrate, that some of his rights have been affected. But today, Milord, if a registration of an FIR does not affect anybody's right. Police My learned friend has used the expression they. I do not know who are the they, but he must be either hinting at the entire state or the police of that area, either of that. Then also, your lordships have held in that Bimal Gulum's case, the Honorable Supreme Court has said, where the police themselves have registered more than 150 odd cases against one person. Supreme Court did not accept the contention that the entire state machinery is biased against him. And therefore, it was not transferred. Therefore, these, I'll come back with my report. Nothing has been shown to have affected their rights as of today. People who are not involved have not been arrested. We have not indiscriminately gone to people's house, and there is no case of police excess also. But I can understand complaints made before the court that in the dead of the night, somebody has been pulled out of his house, battered, assaulted. Nothing of that sort also.
No, the submission is that all the FIRs are open-ended. So you can rope in anybody, anytime, or members of the BJP. This is the expression used in the complaints. Now, relying upon this, if you go and arrest somebody.
I have not as yet. But this apprehension must have a basis. Where the first complaint is, as I find, my lord, on, if I'm not wrong, on 24th of May 2025, 24. 1 month has been over, my lord. As of now, my lord, there is not a single allegation on that. Therefore, my lord, the apprehension must have a basis. But
do you still say that you will not apprehend anybody right now? For the time being, the matter is.
May I tell you, Lordship, if so long, my lord, I have not arrested persons whose prima facie involvement has not been found. We have not arrested anybody based on the complaint or allegations in the FIR per se. If that was our intention, then out of 32 would have arrested 32 if possible.
No, out of 32, 1 was arrested. Out of 17, 2 were arrested. 22, 1 was arrested.
We'll as a sample, I will demonstrate before your lordship any of the case which the court may choose, that if I have arrested 1 out of 17, the involvement of that one person has come out during investigation.
Yes.
I'll definitely satisfy this court's conscience. But my lord, I don't think that all the papers are with me right now. Mr. Banerjee takes the responsibility. My lordship, as a specimen, please tell us one case.
No, you read out Shuman Chakraborty's matter that you handed over.
Shuman Chakraborty.
This is what you read out.
Yes, my lord, in Shuman Chakraborty, my lord, there are 5 cases.
5 cases. You have given the numbers, and the fourth column.
Yes.
The FIR named persons, and out of the FIR named persons, such and so many persons have been. This is what you read out.
Yes. No, what I was suggesting, only
yes.
to satisfy your lordship's conscience, and that, my lord, I have not
acted malafide.
But your lordship may choose any of the case, and I will demonstrate that if I have arrested one person in that case, that arrest was because of some involvement found out during the investigation. And that it is not an indiscriminate arrest because of a allegiance of to a political party. That's what I was trying to. I thought it is not possible, but Mr. Banerjee says it is possible. Huh? Anyone, we can do that. May not be today possible, tomorrow, we can come back.
So, is it, does the court get the impression that you are not immediately arresting anybody out of the cases?
If there is no involvement.
No, if is a big thing. Because
very well.
Depends upon this if.
Very well. May I say this? Kindly do not record. Till your lordship hears out the matter next, I can assure no further arrestment. Please don't record, but I'll send put information on that. But so far as the petitioner number 1 is concerned,
something has to be stated, because police will. Then there are 47 FIRs, and we are actually challenging the very registration of the FIR. So you set up a case against somebody and
If
then
the
say he's involved.
registration is challenged,
and
my lord,
then
then
I-
possibly, my lord, 226 is not the, my lord, right.
Anyway, that we will argue, my lord.
Then
we will argue.
Well, I'm told, my lord, of the persons of whom, my lord, involvement has been found out, there are 2 persons whom we could not apprehend till date.
There are 2 outside.
Which I will try to, my lord, satisfy your lordship's conscience that, my lord, there has been no foul play over here. I have done my duty. Thereafter, if your lordship feels that these are to be quashed, it will be quashed.
Also,
But I don't have any fascination for any investigation or against any person.
also, my lord, learned advocate general said that 2-3 complaints he has written for the BJP. Let those records also come. When was it done? After
That is
Friday?
not my obligation.
No, after Friday.
That is not
we will
my
try to get it.
obligation.
Because
You
we
get
served
it.
a copy on last Friday.
No, you say that this person has not scribed, I am
Yes.
going to place it.
Yes.
But you must take responsibility
Yes,
when
yes,
you have
we will
when
say-
you have made out
will
this
investigate.
case that one person is writing all on behalf of one ruling dispensation, then it is your obligation to say that no, that person has not written on behalf of
Yes,
the
yes.
other dispensation.
Signatures against the
No, you,
Yes,
you have
yes.
to say that.
And there is no left thumb impression in any FIR. All FIRs, there is a tick mark and the person has signed under the tick mark. Please see that also, my lord. Just kindly see that.
I have seen that, and it is also mentioned that this has it is as per the dictation of the
Right.
person who has done
Right.
it.
No.
As
ju-
is done in wills or in
Just
plans
kind-
recorded in
Right.
vernacular, read
That is
out
what
and
I explained.
understood,
Yes, yes.
explained and understood.
But that of
It has
course
been,
said.
so the
But
person
there
is,
Well, would
Just
set
kindly
up a
see
dangerous law.
page
That
108.
will
There is a
people cannot file FIRs.
page 108. Page 108. There is this small tick mark here, and the person is signing above the tick mark.
Gold Mondol is signing. Against that, there is a tick mark.
Yes.
But I can show, my lord, educated people signing over yours faithful.
I mean, so,
that type of education.
so therefore, look, these are FIRs. And what such open-ended 47, 47, and I have read those orders. They started with 6, then 17, now 47, and all against one party. And
Sir, I'll file a report, my lord. Let us not dilate on this, my lord.
Advocate General is saying that it is open-ended. We have 50, 60 people. We are going to find others. So this is all persecution, my lord. No, this is not a prosecution.
No, we have not reached at that stage.
Yes.
We have not reached at the prosecution stage. Therefore, kindly do not compare prosecution and persecution. We are still at the investigation.
There is a Shotto part, right?
Right.
See, in each and every complaint,
Correct.
উক্ত বক্তব্য আমার জ্ঞান মতে সত্য, that's I verify that they are all true to my knowledge and বিশ্বাসযোগ্য.
That's the drafting of the FIR. The man who has drafted. Therefore he's drafting the FIR.
Professional, he is
Professional.
the person who
Yes.
drafts it.
Yes.
Accommodates itself.
Professional draftsman.
Those are all used in affidavits,
My lord,
not in FIRs which are sent.
But the FIR for the BJP, the same tick mark.
Yes.
Tick mark.
The same man is.
Same man with the same tick
Yes,
mark.
but who has done it? That's the point. That therefore there needs to be an SIT. This is a further reason for an independent SIT. That what kind of FIR is this and who is doing it?
Provided it's my obligation to find it out.
Yes.